right, folks, welcome to our first week of class now that we've got the introductions out of the way. Um, Looking at the syllabus, we're starting off with about 4 weeks of copyright review. Um, this class should not be your first exposure to the idea of copyright, but it possibly could be. In any case, we're not going to spend a lot of time on it, but it does require that we address it and give it its just place, which is basically as a condition of um, not just licensing and the job of a publisher, but really the entire idea that music can be a business. So we're going to get into that completely fundamental recognition of the importance of copyright, along with, let's see, trying to get there we go. Along with these steps here, like points that we're going to cover today, which is a sort of concise definition of copyright, recognizing what is required for copyright to kick in, so the requirements for the protection that copyright affords. What rights do copyright owners actually enjoy? What does the law provide for them to have in terms of rights? And then a kind of general historical, back up and get that, forest for the trees type of perspective on how we got where we are, where copyright came from. And so that sort of United States version of an idea that's really been in place. It's an Enlightenment idea. It's early 18th century, so 1710, I think. Once we get out of this idea that everything that people create has to be approved by the king, so things start to stand on their own in terms of industry and craft and trade. Copyright comes shortly after that idea. Okay, so what actually is copyright? I think to properly respond to that question, you've got to look at how U.S. law considers personal property, or considers property at all. So personal property is held in distinction from what's called real property. And it doesn't mean that personal property is not real. It's the version of real that you see in real estate. And so real property is actually land. And so that is what governments, put armies on the ground to kill and die for, right? So land and the acquisition of land, so that's real property. And so as citizens of the government, of a country, we everything we put on that land that's our personal property. But we don't actually own the land. That's why there's property tax. You may buy a house, and the house comes with a certain amount of land, but there's such a thing called eminent domain, which means that if the government needs that land for some reason, like to house troops, or to build an interstate, then the whole idea that that's your land is out the window pretty quickly. But so that's the distinction between real, as in land or real estate, and then personal property is what we put on the land. And personal property comes in these two different kind of versions, right? So you've got anything physical like a car or a house or your stereo system, but then there's also intellectual property. And so the ability to protect that which you cannot see is where copyright comes in. So if you come out of your house in the morning, you're like, oh my God, somebody stole my car. It's pretty obvious, but it may take you weeks or months to realize that someone has stolen your song, or some other version of intellectual property, like has duplicated your book, or taking your plans, your architectural plans, or is duplicating your photograph. All these different kinds of intellectual property are much harder to track and to control, and so copyright provides a process for that, a legal process. And as a result, usually we see that theft of intellectual property has occurred by following, a revenue trail, meaning that there's lost sales, or that money is going to the wrong location, right? And an infringer, someone has stolen intellectual property, they're claiming the money that belongs to the author or the owner. And so you need to, if you are an owner, then you've got basically 3 years from the time of the infringement itself to recognize and to file suit, to kind of straighten this out in the court of law. So we'll get into that part of it when we get, into infringement in court cases and things like that a little bit later. Okay, so back to what is copyright? So you've got to have these 3 boxes checked in order for copyright to basically kick in, which is a cool thing about it in the United States, is you don't have to actually register it with the government. As soon as your work is original, it's, fully played out. It's not just an idea. So it's an expression. It's an original expression that is fixed in a retrievable medium. Then guess what? You are now a copyright owner, and you have all of the benefits, with the exception of a couple that we'll get into, that the federal government can provide for copyright owners. So that's pretty cool. A couple things to recognize here. First of all, originality is not an easy concept, because if you look back at the very first artwork that's attributed to humankind, it's not abstract, right? It's a representation, meaning that the drawings on the inside of the caves in southern Europe from 20 and 30,000 years ago, those are basically antelope, horses, things of nature. And so the myth of original creation has to take into account the fact that there is no truly original creation, that we're always inspired by something that came before us. And so copyright law is a little bit more nuanced than saying that it has to be original. It should be a recombination of a certain amount of works. So I wanted to kind of nuance that a little bit for you. In terms of the expressed idea, you can't just say, you can't copyright an idea like, okay, I'm going to copyright the idea of love, right? And so everybody who writes a love poem or draws a picture of a heart on Valentine's Day, they owe me a royalty. That's, ridiculous. But if you write a poem on that, then you're expressing that idea in some fashion. And the particular expression, your originality, is conveyed in the exact words that you choose, and the syntax or the order of those words, and what rhymes you're going to have, and the different images that you play up, and what's the perspective between the speaker, and the object of the poet's affection. So all of those are very specific expressions of an idea that are not subject to copyright. They can't be protected unless they're actually fixed, meaning that put into a medium, like you write them down onto a piece of paper and a computer, or you make a video, so that there's a specific version that is yours. And so that can be verified that this rhyme and this, particular expression of this poetic idea belongs to you. So that's why all of those 3 things are required for copyright to actually kick in. So things that are protected by copyright are contrasted by things that are unable to be protected by copyright. So we mentioned, ideas, they don't belong to, they're unable to be copyrighted. But, copyright doesn't last forever. And so when something, the length of its copyright protection runs out, it no longer belongs to that individual, but it belongs to everybody in that country. And so it's public property or the public domain. And so the public domain is the sort of opposite, right? It's the other side of the copyright coin. Copyright lasts for a little while. You've got protection. And then when that ends, then works go into what's referred to as the public domain. And so if you look at the right side of this slide, you'll see that facts, names, titles, works that are not fixed, right, that are not concrete, works created by the government itself, those are not subject to protection. Some works online that are in the Creative Commons, there used to be language on YouTube that you were uploading a work into the Creative Commons, meaning that people could use it, but they just had to give credit where credit's due. And so that's Creative Commons. So all of these mean that these works can be used by you, by me. And what should also be included in there would be expired works. So usually works from before the year 1923 are considered part of the public domain. So you can take old maps and put those together and put out a version, a collection of maps from the 19th century and make money on that, even though you didn't draw one of those maps. On the other hand, what we're really interested here, the public domain serves to kind of define, where copyright starts and stops. What is copyrightable? So on the left side of the slide, you see musical works, right? That's primarily what we're going to be looking at here, is how to use musical works and recordings. So you see sound recordings down there. Within these other types of media, so dramatic works and motion pictures in particular. But it's interesting to see, architecture, sculpture, photography, literature, even an email, right? That satisfies all of the things. It's a particular expression in a concrete, medium, which is the email itself. And so those are works of the mind, right? Intellectual property. Okay, so that's what's copyrightable. Okay, we talk about concreteness in a song. So there are some gray areas, of course. That's why copyright cases end up in a court of law, where you have to argue, ownership and things like that. So concreteness is, you can appreciate in terms of a matter of degree, right? So the least concrete is up at the top, where the negative mark is. That's going to give you the weakest claim of ownership as a creator. And then you get down to the bottom of that list, number 5, where the plus mark is. Those are going to be the most concrete. And you can see the music publisher, has a place within here. And so performers go out. You've written a new song. You go out on the street corner and you perform it. Those elements came together, but would a passerby be able to recite, the specific melody and word choices? Possibly if they had a photographic memory for the next 10 minutes, but what about 10 years down the road? Okay, so performance is very weak, ethereal, right? It's fleeting. You write it down, it becomes a little bit more concrete there, depending on what you write it on and how well you keep your records. You record it, especially for sound recordings or different kinds of performances, more concrete still. When you publish it, now you've got different people in the industry that are recognizing it and buying into it. They've got a stake, they're a stakeholder. At that point, it becomes very concrete. And then finally, you register it with the U.S. government, which is, once again, not a requirement for full copyright protection, but there are some benefits that come along with that. Okay, so it's important to understand copyright in terms of the concreteness of the particular work that you're dealing with. Now, when you apply that to the music business, there's really 4 streams of income in the music business, but 3 of them are based on intellectual property in the way that we're dealing with it now, which would be looking primarily at songs themselves and recordings of those songs. So up until the digital revolution, so approximately the dawn of the 21st century, record companies ran the music business. They were 2 to 1 in terms of value over any over songwriting and the public performance of the concert industry. And so, the recording is a captured performance, and it has its own copyright, which we'll get into. That P with a circle around it stands for phonorecord, or the recording of sound. And so songwriting, the second stream of the music business, and these are income streams, right? So how does revenue flow, right? So through the record companies by selling their Circle P, through music publishers by licensing their Circle C. And so songwriters need publishers, as we'll get into, to place their compositions in all of these different areas, TV, print publishing, record companies, cover songs, live venues, all of that is music use. And that's what music publishing finally gets down to. But they're looking at Circle C there. Music publishers don't tend to handle master use or Circle P. And so you're starting to see a little bit of the complexity here. I'm going to try and keep this class as simple as I can, but when you get lawyers and politicians, lawmakers involved, and the music business itself with technology, you can imagine this. There's a need to simplify and to understand clearly, so I'm going to try to do my best. And finally, you get down to performance. So performance in the music business, from licensing and copyright at least, is understood not just as a concert, but also as a broadcast. And so both Circle C songs and Circle P, the recordings, have revenue that's kicked up whenever they are broadcast, either streamed or played on a radio, played online, or in the case of songs, performed live at concerts. So this is to show you the application of this idea of how copyright enables revenue flow in the music business in the way that we traditionally understand it, in terms of record company place of music publishers there in the middle, and then they typically will offer these other licenses. So number 3, the performance license, sometimes does, but most of the time actually does not go through a music publisher, but that's fine. We'll just move on through. Okay, so what do you actually get? Okay, you're going to see this a lot, so I'm just going to show it to you now as a first time, but this is really, really crucial to the relationship between copyright and licensing. So, you write that email, boom, you're a copyright owner, right? You don't have to register it with the government. Once again, I'll show you the benefits you get for registering it with the government in a little bit. But what does being a copyright owner mean, right? So, according to the 1976 Copyright Act, there are 5 primary rights of copyright ownership. They're called the bundle of rights, and they're easy to remember. 4 Ds and a P: duplication, distribution, derivatives, and display are your Ds, and then the right of performance. And so those are the rights that you get. How do they become, monetized? Then you look over to the right. And so anytime that somebody, a business, for example, like a record company, wants to use wants to make a record, they actually have to make a record of something, right? So they're using Circle C to make Circle P, right? They're using the composition to make the phono record. And so they need the right of duplication and distribution in order to do that, right? They're going to duplicate it, the song, and into all of these different, CDs or streams or whatever it is. And then they're going to put those out into the world. They're going to distribute it out into the world for sale in order to make money, right? And so copyright simply protects the original creators so that they're part of that money-making process. Derivatives, if you have a translation of a work from English to French, or if you have like turning a book into a play, or a play into a movie, that would be a rights deal. Those are examples of derivatives. And so that's another right that whoever owns the original work can say, no, you're not going to translate my book, or you have to have my permission, or turn my book into a play, right? So I have the right to allow for derivatives. The right of display, the right of performance, these are all part of the bundle of rights that copyright owners get as soon as they check those boxes of originality, expressed idea, and it's put into a fixed medium. Okay, so we're going to come back to that several times during the semester, but I just want to put this on your radar as this sort of core idea of how copyright and licensing intersect. Okay, now to really understand copyright as it comes into the United States, you can do so by art form and by date. Once again, the idea is not original to the United States. It originates in terms of the very first law in the United Kingdom, I think 1710, with the Statute of Anne, which is the first time that authorship equals ownership. So instead of the creation of citizens defaulting to the king, right, which is how it was before, and the king's publisher, which would give permission if the ideas expressed in the art coincided with what the king thought was good. That whole system there was replaced ultimately by a more democratic ideal, which we find in the early 1700s. And so that's that if you're an author and you're good enough to create something that's interesting, and then the Statute of Anne says you should benefit from that as an individual. It doesn't necessarily have to be in the service of politics or the king in that case. Fast forward 80 years, we've got the American Revolution has taken place, and now we've got the Constitution. And so the Constitution says, whatever kind of works we've got going on here at this early stage in 1790, primarily maps, books, charts for charting and mapping a new land, very important. We're going to protect those for 14 years, and if you're still making money off of it after 14 years, then you get this renewal term, which is another 14 years. So at the founding of our country, copyright was a maximum of 28 years protection. But if you weren't making money off it, it could be as little as 14 years. So you get 14 years initial term, 14 years renewal term for a max of 28. Fast forward about 40 years, and we add songs to the list. There we go, 1831. Songs are added to what can be copyrighted. And the initial term is now 28 years, and the renewal term is 14 years. So you can see a benefit for owners. Now, who's losing out on that deal? Who doesn't get to use the songs? That's the rest of the public, right? They have to pay longer and can use it as their own work only after, in that case, that's 38. That's 42 years total as opposed to 28. Plays are added to the list in 1856, motion pictures 1912, etc. So you'll need this to fill out this week's assignment, which is the copyright timeline. So you want to look at this week's assignment on Canvas and take care of that. Another way to look at the copyright history in the United States is just by the duration. And there's an interesting trend there, I'm sure you'll notice, and we'll talk about that when we get to duration. We're going to spend some time on how to figure out when a work has expired or gone into the public domain. So you should be able to do that as a student of copyright and licensing, because there's no need to license something that's already free, and that's what works of the public domain or expired copyright offers you. So when you look at U.S. dates by duration, 1790, 1831, 1909, you see 14 plus 14. That's that 14-year initial term, 14-year renewal term. 1831, as we mentioned, it changes to 28-year initial term. If it's still making money and you want to, you can exercise the renewal term. 1909, now it's 28 of the initial term plus another 28, and that's really the first major copyright law after the original language. So the Copyright Act of 1909 is pretty significant. It adds like compulsory mechanical licensing. That's why I've got mechanicals out there to the right. We'll certainly get into that later, but just to recognize that the relationship between technology, where you've got the ability to mechanically reproduce, here you've got piano rolls were really what was doing most of the driving. That was the technology that drove that particular law, but it immediately applied to records, which had been produced since the 1890s, roughly. 1976, now you've got, for the first time, copyright duration is based on the life of the author, interestingly enough, instead of just an arbitrary number. So we've got the life of the author plus an additional 50 years. And then the Copyright Term Extension Act of 1998, that's what CTEA stands for, once again bumped it. So, and that's what it currently is, the life of the author plus an additional 70 years. And so these are some ways that you can understand copyright from a historical point of view, is by how different works of art have been written into copyright law. And then you've got different times of protection that last. Okay, so let's test your memory here. Do you remember what real property is as opposed to, say, personal property? What is a fixed creation as opposed to an unfixed work? The public domain? What could this possibly be? So those are some terms that you'll want to remember. We just talked about the CTEA, that's the last one, Copyright Term Extension Act. So those are some terms from today's first presentation that you'll want to make note of because you'll be seeing them again. All right, please do post your comments, in particular questions, in the comments section, and I look forward to hearing from you. Have a great day.